Okay, let's unpack this. Picture this. A quiet afternoon, North Stradbroke Island, Queensland, September 2013.
Beautiful spot, usually peaceful.
Until it wasn't, suddenly just this raw sound of impact, a head-on collision.
Yeah, a Toyota Tarago, family inside, hits a Nissan Patrol, violent crash.
And the immediate result, just devastating. A 17-year-old Lien-Yang Lee suffers these horrific spinal injuries.
Partial tetraplegia. His life just completely changed right there in an instant.
It's awful. And, pretty quickly, everyone agreed on one thing.
Right, the driver of the Toyota, whoever it was, they were negligent. The crash itself, their fault. No real argument there.
But that's where the agreement ended, because right there, amid all the trauma, this huge question emerges, one that would fuel years of legal battles.
The multi-million-dollar question, really. Who was actually driving that Toyota?
Was it Lien-Yang, the son? Severely injured, yes, but also unlicensed, 17 years old.
Or was it his father, Chin-Fu Lee?
Such a simple question on the surface, but the stakes couldn't have been higher.
Absolutely. We're talking agreed damages if the father was driving of $3.35 million. Serious money.
And it didn't stop there. Later on, the insurer, RACQ, they brought serious allegations. Deceit against the whole family.
Yeah, this went way beyond just a simple negligence claim. It became about truth, identity, how you piece together evidence after a traumatic event.
So that's what we're doing today. We're taking a deep dive into this case, Lee v. Lee, a real legal drama that went all the way up through the Australian courts.
We'll unpack it all, introduce you to the key players, the people involved.
Look at the crucial evidence, what people said, what the science showed, the experts battling it out.
And crucially, how this single case actually ended up reshaping how Australian courts, especially appeal courts, review facts and the conclusions drawn from those facts. It's quite significant.
It really is. A complex story, but fascinating, showing how every little detail matters when you're searching for justice.
So let's meet the players, the cast, if you like. At the absolute center, of course, is Lien-Yang Lee, the injured son. His life just shattered. In the legal documents, especially later on, he's often just called the appellant.
Then there's the person Lien-Yang said was driving, his father, Chin-Fu Lee.
Right. His actions right after the crash and things he said later, and maybe most importantly, the fact he didn't testify at the first trial, all under intense scrutiny. He's referred to as the appellant in the third appeal in the high court stuff, or just the father.
And the mother.
Xiao. She owned the Toyota. Her evidence about what she saw right after the crash was also key. She's the appellant in the second appeal, or the mother.
We also have someone crucial who wasn't in the Toyota.
Mr. David Hannon, the driver of the other car, the Nissan Patrol, an independent witness.
Yeah.
His account of those first few moments, what he saw, that was vital and, largely undisputed.
Okay, so that's the family and the witness. Who are they up against?
RACQ Insurance Limited,
Oh.
the compulsory third-party insurer for the Toyota. They were the ones defending the claim, the ones potentially on the hook for that $3.35 million.
Yeah. And they didn't just defend, right? They counterclaimed.
Exactly. They mounted a really robust defense and went further, alleging the family was involved in deceit, trying to cover up who was driving.
And their legal team?
Yeah.
They were a constant presence.
Remarkably so. Gilchrist Connell lawyers, led by R.J. Douglas QC Queen's Counsel, a senior barrister, and B.F. Charrington. They represented RACQ right through every stage. Trial, court of appeal, high court. That consistency is quite something in long litigation.
Okay, so RACQ had their steady team. What about the family? It sounds like their representation shifted a bit.
It did. That's interesting. At the first trial, the big one in the Supreme Court of Queensland, Lien-Yang had Slater and Gordon lawyers, with GW DMQC and M. Callahan as his counsel.
Okay.
His mother, Xiao, had a different firm, Little's Lawyers, with M. Grant Taylor QC and J.M. Hewson.
And the father, Chin-Fu Lee?
This is notable. At the trial stage, he represented himself, no lawyers.
Wow, okay, that's a big decision in a case like this.
Huge. Then, when it went up to the Queensland Court of Appeal, before Justices of Appeal, Fraser, Philippides, and McMurdo, the mother and son kept their teams, broadly. Still Little's involved. But the father, he still represented himself on that first appeal.
Still on his own.
Yeah. But then, for the final step, the High Court of Australia, the top court, before Chief Justice Kiefel and Justices Bell, Gageler, Nettle, and Edelman.
Things changed.
Big change on the family side. For the first time, all three, Lien-Yang, his mother, and his father, were represented by the same legal team. Little's lawyers instructed GWD and QC and M. Callahan for everyone.
So they finally presented a united front legally at the highest level.
Exactly. While RACQ, as we said, stuck with their consistent Gilchrist-Connell team, Douglas QC, and Charrington.
Okay, so we've got the players, the legal teams mapped out across the journey. Let's get into Act 1, the trial. Supreme Court of Queensland, before Justice Boddice.
Right. And the entire focus, the sole issue for the judge to decide, was that one question. Who was driving the Toyota?
So how did the family present their case? What was their story?
Lien-Yang testified first. He said he was a passenger, he'd fallen asleep before the crash happened. He only remembers waking up outside the car afterwards.
His mother.
She testified she saw her husband, the father, get out of the driver's door right after the impact. Then she heard him in the back of the Tarago helping their other younger children who were also in the car.
And they had another son testify.
Yes, James, the younger brother. He said he remembered his father being the one driving just before he himself fell asleep, before the accident.
Okay, so a consistent story from the family members who testified, but the father didn't.
Correct. Chin-Fu Lee did not go into the witness box at the trial, a very significant absence.
But there was a statement from him, wasn't there? The one RACQ put in.
Yes, exactly. This statement he gave to an RACQ investigator sometime after the crash. And it was RACQ, the insurer, arguing he wasn't the driver, who actually tendered it, formally put it before the court.
Which still feels weird. Why hand the judge a statement where the father claims he was driving if you're arguing he wasn't?
It was all about strategy, undermining credibility. In that statement, the father, Chin-Fu Lee, claimed, yes, he was driving. He said his seatbelt was on, but it jammed after the crash. He claimed the blood on the driver's seat was his, from cuts on his hands, from glass. And crucially, he claimed his son, Lien-Yang, wasn't bleeding at all immediately after the crash.
Okay, but how did RACQ use that?
They used it to show just how unreliable it was. They pointed to other evidence. Hospital records show the father didn't have significant hand cuts needing treatment. Eyewitnesses, like Mr. Hannon, and even a doctor who arrived on scene, Dr. Lee, confirmed Lien-Yang was bleeding heavily from facial injuries.
So RACQ's point was, look, this statement is full of holes. It doesn't match the objective evidence. Therefore, you can't trust anything this family says. It supports our deceit claim.
Precisely. It was a calculated risk to show inconsistency and alleged fabrication.
Okay, I get it now. What about Mr. Hannon, the independent driver? His evidence sounds really important.
And solely critical. He arrived so fast, 30 to 90 seconds. That's incredibly quick.
What did he see in that window?
He was clear. When he got to the Toyota, nobody was in the driver's seat. The father, Chin-Fu Lee, was already standing in the rear section of the van helping the kids. Mr. Hannon actually helped the father get the children out.
So that immediately raises the question. If the father was the driver, how did he get out, injured or not, and get to the back so quickly? And if the son was the driver, how did he get moved?
Exactly. Hannon's testimony created a major logistical puzzle for either scenario, especially given Lien-Yang's paralysis. How does a severely injured person disappear from the driver's seat in under 90 seconds?
And the scene itself, what did the police find?
Senior Constable Pepper noted blood stains on the driver's airbag. He also saw the driver's seatbelt was buckled, clicked in.
Which fed into that early police suspicion.
Yeah, the idea that maybe Lien-Yang, being 17 and unlicensed, had been driving and had just clipped the belt in behind him to stop the warning buzzer. That was an early theory floating around.
And other evidence. The father's hands.
Confirmed bloodstains on his hands. Seen by Dr. Lee at the scene, and also visible in photos taken later. Consistent with him helping his bleeding son, or perhaps from his own minor cuts mentioned in the statement. Open to interpretation.
Then came the science, the DNA.
RACQ's big gun. Samples were taken from the driver's airbag the day after the crash.
And the result.
Lien-Yang Lee's blood was on that airbag. DNA match. Critically, though, they found no DNA from the father on the parts of the airbag they sampled.
Where exactly was the blood on the airbag?
Interestingly, not really dead center where you might expect a direct faceplant. It was more on the windscreen side of the airbag, sort of left and right edges, and even some on the underside.
Okay, DNA, positive for the son, negative for the father, specific location. This must have led to a clash of experts trying to explain it.
Oh, absolutely. A classic battle.
Yeah.
RACQ brought in Dr. Robertson, a pathologist. She looked at the bloodstain pattern.
And her conclusion.
She testified they were consistent with direct contact from a bleeding face like Lien-Yang's severe facial injuries. Spatter patterns, she argued, not just simple transfer marks.
But she admitted it wasn't an exact science.
She did, yes. Bloodstain pattern analysis has its limits, but the trial judge found her evidence very persuasive. RACQ also had Dr. Weidman, a neurosurgeon.
His take.
He felt Lien-Yang's specific severe spinal injury was more likely if he was an unbelted driver thrown forward into the airbag. And Professor Mansour agreed the facial injuries matched hitting an airbag.
So RACQ's experts painted a picture. Unbelted son hits airbag, leaves blood, sustains injuries consistent with that.
That was their narrative, supported by their experts. But the family had their own experts with different views.
Like Dr. Grigg, the engineer.
Yes, and his evidence turned out to be incredibly important, especially later. And importantly, it was unchallenged by RACQ. They didn't really cross-examine him heavily or offer engineering evidence to counter it.
What did Dr. Grigg say?
He talked about how modern seatbelts work, specifically pre-tensioners. On impact, they fire, instantly yanking the seatbelt tight, pulling the occupant back firmly into the seat.
Okay.
He also testified about how quickly airbags inflate and then deflate, almost instantly. So his point was, if the driver was wearing their seatbelt, the pre-tensioners would hold them back, making direct, forceful facial contact with the airbag, especially enough to leave bloodstains on the sides, much less likely. The pattern didn't fit a belted driver, in his view.
So his evidence directly challenged the direct contact theory if the driver was belted.
Precisely. And the family also had Dr. Campbell, another neurosurgeon. He argued Lien-Yang's spinal injury could have happened in any seat. It wasn't definitive proof he was the driver. And a sleeping, belted passenger could potentially suffer such an injury in a violent crash.
Okay, so competing narratives, conflicting expert opinions, questions about credibility. How did the trial judge, Justice Boddice, pull all this together?
Well, his findings were absolutely critical. And, as we'll see, quite controversial later on. First, credibility. He wasn't impressed with Lien-Yang or his mother on the stand, found them unreliable, evasive.
And the appeal court later noted he made a mistake about an interpreter.
Yes, the Court of Appeal pointed out he wrongly recalled Lien-Yang using an interpreter when he hadn't. But appellate courts are generally very reluctant to overturn credibility findings. They usually defer to the trial judge who saw the witnesses. So, despite that error, the core finding of poor credibility largely stuck, at least initially. He also didn't put much weight on the father's contradictory statement, seeing it as unreliable.
Okay, so he doubted the family's testimony. How did he handle the physical evidence, the seatbelt, the DNA?
This is the absolute linchpin of his decision. Justice Boddice made a crucial finding that went against what both sides had essentially assumed or argued throughout the trial.
Which was?
He found that the driver, whoever it was not wearing the seatbelt at the time of the crash. He speculated it might have just been clipped in behind them to silence the warning alarm.
Wow. So he rejected the idea of a belted driver entirely, even though that's what the experts like Grigg were discussing.
Exactly. And that finding driver unbelted became the foundation for how he interpreted everything else.
Oh, so?
Well, if the driver was unbelted, they would be thrown forward violently. So he accepted Dr. Robertson's DNA evidence as highly persuasive. Direct contact from Lien-Yang's bleeding face onto the airbag seemed plausible if he was unbelted.
And the alternative theory? Blood transferred from the father's hands.
Justice Boddice rejected that as improbable. Why? Because his primary finding was unbelted driver hits airbag directly.
Okay. And the injuries?
He accepted the medical opinion, like Dr. Weidman's, that Lien-Yang's specific spinal injury was more likely if he was an unbelted driver hitting the airbag. It fit the narrative.
Even the difficulty of moving a paralyzed person in 90 seconds. How did he deal with Mr. Hannon's evidence?
He acknowledged the tight time frame, but concluded it was not improbable that the father could have moved his paralyzed son to the rear seat that quickly. He essentially discounted the difficulty.
So let me summarize his logic. Find the driver was unbelted. That makes direct airbag contact by Lien-Yang plausible. That explains the DNA. That fits the injury pattern, more likely if unbelted. Discount the difficulty of moving him. Therefore, Lien-Yang was the driver.
You've got it. That was the chain of reasoning. And based on that, Justice Boddice found entirely for RACQ. Lien-Yang's claim was dismissed, and RACQ won their counterclaim for deceit against the family.
A total loss for the Lee family at trial, but, as you said, not the end of the road. They appealed.
They did. They took it up to the Supreme Court of Queensland, Court of Appeal. That's the Intermediate Appeal Court. Remember, the father was still representing himself at this stage.
And what's the job of the Court of Appeal? Do they just look for mistakes in law?
It's broader than that in cases like this. They conduct a rehearing, but based on the written transcript and evidence from the trial. They have to give real consideration to the trial judge's findings, especially on credibility, because the judge saw the witnesses. It's often called the principle of appellate restraint.
So they review the facts, But they're generally hesitant to overturn the trial judge unless something is clearly wrong.
That's the traditional approach, yes.
Yeah.
And the QCA itself described this case as very closely balanced. It wasn't obvious.
Did they find any errors in Justice Boddice's decision?
Oh, yes. Some absolutely crucial ones. Findings that really struck at the heart of his reasoning.
Like what?
The biggest one, the seatbelt. The Court of Appeal found it was more probable than not that the driver was wearing a seatbelt.
Whoa, that completely contradicts Justice Boddice's foundational finding.
Completely. They pointed out the belt was buckled, likely locked by the pretensioners Dr. Gregg talked about. This finding alone demolished the unbelted driver thrown forward scenario that underpinned the trial judge's view of the DNA and injuries.
Okay, that's huge. What else did they correct?
The difficulty of moving Lien-Yang. They found it was much more difficult and improbable to move a paralyzed teenager to the rear seat in under 90 seconds than it was for the father to simply get himself out of the driver's seat if he'd been driving. Directly opposite to the trial judge's conclusion.
So they're saying the timing didn't work for the son being moved.
Pretty much. Justice McMurdo, writing the lead judgment, explicitly said that if you ignored the DNA evidence for a moment, the sheer improbability of moving the son that quickly strongly pointed towards Lien-Yang not being the driver.
Okay, corrected the seatbelt finding, corrected the moving the son finding. Anything else?
They also found the injury evidence was basically neutral. It didn't strongly point to driver or passenger either way, disagreeing with the trial judge's leaning there.
So they're systematically taking apart the trial judge's key factual conclusions. What about credibility? Did they reassess that?
They noted the trial judge's error about the interpreter, but ultimately they still felt bound to largely defer to his overall negative assessment of the family's credibility, citing that trial judge's advantage.
Okay, so here's the puzzle. They corrected fundamental factual errors, the seatbelt, the moving improbability that underpinned the original decision, but they deferred on credibility. What did they do with the DNA evidence in light of their own corrections?
This is where it gets really interesting and, well, legally complex. Even though they'd found the driver was belted, they still found the DNA evidence highly persuasive in favor of RACQ.
How? If the driver was belted and held back by pretensioners, how did they explain the blood on the airbag?
They leaned on Dr. Robertson's opinion again. They reasoned that even with the seatbelt, some small movement of the head might occur, and therefore direct contact couldn't be readily rejected. They felt the DNA evidence, suggesting direct contact, remained quite probable, even in a belted scenario.
That feels like a stretch, trying to fit the DNA evidence to a scenario it didn't initially seem to support, especially given Dr. Gregg's unchallenged points.
It's certainly where the High Court later focused its critique. But the QCA felt constrained. They'd found these major errors in the trial judge's reasoning, in his inferences from the facts. But they hesitated to take the final step.
Why? Because of appellate restraint?
Exactly. They felt that even with the corrected facts, the trial judge's ultimate conclusion, Lien-Yang was the driver, wasn't necessarily glaringly improbable or contrary to compelling inferences. They basically said the trial judge got some key steps wrong, but maybe he reached the right result anyway and we shouldn't interfere.
So they identified the flaws but didn't overturn the outcome.
Correct. They dismissed the appeals, they corrected the reasoning on key points, but ultimately upheld the original verdict favoring RACQ.
Wow. So the family wins on correcting the facts but loses the appeal. That must have been incredibly frustrating.
You'd imagine so. And it perfectly set the stage for the final showdown, the High Court of Australia.
Australia's highest court. And now, as we said, the whole family had one legal team, Little's lawyers, DMQC, and Callahan. What were they arguing this time?
Their arguments focused squarely on what the Court of Appeal did or perhaps didn't do. Two main grounds.
Okay, first.
Did the Court of Appeal actually fail in its duty to give proper reasons? Specifically, by not adequately grappling with Dr. Gregg's unchallenged engineering evidence about seatbelts and airbags after they themselves had found the driver was in fact belted.
So did they ignore evidence that contradicted their conclusion on the DNA?
Essentially, yes.
Yeah.
Did they fail to logically connect their own finding, driver belted, with all the relevant evidence, including Dr. Gregg's? That was the first ground.
And the second ground?
This went right to the heart of appellate review. Did the Court of Appeal show too much deference, too much restraint? Did they rely too heavily on the trial judge's advantage? when they themselves had found the trial judge's inferential reasoning, how he connected the dots, was fundamentally flawed because it rested on that wrong seatbelt assumption.
So was the QCA wrong to just check if the outcome was glaringly improbable instead of deciding the case themselves based on the corrected facts?
Precisely. And the High Court's analysis on these points was powerful. It really clarified the law here.
How did they rule on the first point about Dr. Griggs' evidence?
They agreed with the appellants. The High Court said, yes, the QCA mentioned Dr. Griggs' evidence, but they failed to properly integrate it when they reassessed the DNA evidence under the corrected premise of a belted driver.
Why was that integration so important?
Because, the High Court said, Dr. Griggs' unchallenged evidence pre-tensioners pulling the driver back, rapid airbag deflation made Dr. Robertson's opinion about direct contact, explaining the bloodstains, especially on the sides of the airbag for a belted driver, distinctly less sustainable. It just didn't add up logically. The QCA saw the pieces but didn't follow the logic through.
Okay, so the High Court found the QCA's reasoning on the DNA post-correction was flawed. What about the second point, the appellate restraint issue? This sounds like the big one for legal principle.
It really is. The High Court delivered a landmark clarification on the limits of the trial judge's advantage. They said, yes, the trial judge's assessment of witness credibility is important and deserves respect, but that advantage carries much less weight when the trial judge's findings are based on flawed inferential reasoning from established facts or uncontroverted expert evidence.
So if the judge's logic in drawing conclusions from the evidence is faulty, the appeal court doesn't have to defer as much, even if the judge saw the witnesses.
Exactly. The advantage is mainly in assessing truthfulness based on demeanor, not in the logical analysis of objective evidence or expert testimony. Here, Justice Boddice's interpretation of the DNA and injuries was built on the faulty, unbelted driver premise. Once the QCA corrected that premise, they couldn't just defer to the trial judge's flawed reasoning anymore.
So what should the QCA have done, according to the High Court?
They shouldn't have just asked if the trial judge's outcome was glaringly improbable. Their duty, the High Court stated emphatically, was to conduct a real review. They needed to step back, look at all the evidence through the lens of the corrected facts, driver belted, moving son improbable, and decide for themselves which hypothesis, father driving or son driving, was actually more probable on the balance of all that evidence, logically combined.
A real review. Not just checking for obvious errors, but actually weighing the evidence themselves once fundamental flaws were found.
That's the key takeaway. And applying that principle, the High Court did exactly that. They conducted their own review.
What did they emphasize?
They accepted the extreme improbability of moving the paralyzed Lien-Yang in that 90-second window. Big point against him being the driver.
And the DNA.
They reassessed it, crucially, in light of the belted driver finding and Dr. Griggs' unchallenged evidence. This made the direct contact theory, which really needed an unbelted driver to work convincingly, look far weaker.
So what was the alternative explanation for the son's blood on the airbag?
The alternative transfer. That the blood got there indirectly, perhaps from the father's hands, which were known to be bloodstained from helping his son touching the airbag area while trying to get out or help. With the direct contact theory weakened, this transfer hypothesis couldn't be dismissed as improbable anymore. The High Court basically said it was at least as likely, if not more so, than direct contacts from a belted driver.
Okay, so pulling it all together.
Right.
The extreme improbability of moving the son, the reevaluated DNA evidence making transfer plausible, Dr. Griggs' unchallenged engineering points, the contradictions in the father's statement. Where did the High Court land?
They concluded that, on the balance of probabilities, the hypothesis that the father was the driver was the more probable conclusion when all the evidence was correctly understood and logically put together.
So they overturned the lower courts.
Completely. They allowed the appeals by Lien-Yang, his mother, and his father. They set aside the orders of the Court of Appeal and the original trial judge.
And the practical outcome, the damages, the deceit claim.
Judgment was entered for Lien-Yang Lee for the agreed damages, $3.35 million, payable by RACQ. And the High Court ruled for the father, Jinfu Lee, on RACQ's counterclaim for deceit, effectively dismissing RACQ's allegation that the family had lied.
And costs. Legal costs can be huge.
RACQ had to pay the Lee family's legal costs for the entire Journey trial, Court of Appeal, and the High Court. A very significant financial outcome on top of the damages.
So, a complete reversal. A long, hard-fought battle ending with victory for the Lee family. Beyond their specific case, though, what's the lasting impact of Lee v. Lee on Australian law? Why is it considered such an important case?
It's become a really significant authority, a leading case. on the principles of appellate review. It fundamentally clarified how intermediate appeal courts are supposed to do their job when reviewing decisions based on facts and inferences.
By defining the limits of that trial judge's advantage.
Precisely. It confirmed the advantage is strongest for credibility based on seeing witnesses, but it diminishes significantly when the trial judge's reasoning from facts, especially objective or expert evidence, is shown to be flawed. You can't just defer to flawed logic.
So it emphasizes logic over just witness demeanor in certain circumstances.
In a way, yes. It shows that even if a trial judge has doubts about a witness's credibility, that doesn't automatically win the day if the logical interpretation of other, more objective evidence, scientific engineering, circumstantial points compellingly in the other direction. The pieces have to fit together logically.
And it encourages those appeal courts to be more robust.
Definitely. It's a clear signal to intermediate courts across Australia. Perform a real review. Don't be overly hesitant. If a trial judge's reasoning is flawed, you have a duty to re-examine the evidence properly and, if necessary, substitute your own conclusion based on a sound analysis of all the evidence.
So what does this all mean for the average person or for the justice system overall?
It means, hopefully, greater accountability in judicial decision-making. It reinforces that finding the truth in complex cases isn't just about deciding who seems more believable on the stand. It requires a careful, logical assembly of all the pieces, testimony, yes, but also science, expert opinion, circumstance. And appellate courts play a vital role in ensuring that logical process is sound.
It's so important, too, to bring it back to the human story here. Behind all the legal arguments and principles, there's Lien-Yang, a young man whose life was changed forever by that single, terrible event. It's a reminder that these cases have profound personal consequences.
Absolutely. And the final outcome here wasn't achieved easily. It wasn't based on a simple confession or straightforward testimony. It came through this incredibly meticulous process, examining the scene, the science, the mechanics, the timing, and relying on rigorous appellate review to correct earlier missteps in reasoning. It shows the system, even when complex and slow, can work to uncover the most probable truth based on evidence.
So a final thought for you, our listeners, to mull over something arising from this case. How does Levy-Lee highlight the critical, sometimes decisive role that expert evidence, the engineers, the doctors, the scientists plays in modern courtrooms, and perhaps more fundamentally, the constant challenge for judges at every level? How do you ensure your final decision truly reflects a logical integration of all the reliable evidence, even when that evidence might clash with initial gut feelings or assessments of witness credibility?
It's that rigorous integration of all evidence that Levy-Lee champions, a critical lesson in the ongoing pursuit of justice.